all the old guidelines as archived. So we're in the midst of rearranging the documents accordingly on our website. So please bear with us. At the moment, we just lump everything in one tab on CPCs and guidelines for July 2022. But later on, we will rearrange it accordingly when we will have a tab on archive document. The reason which we have to archive the old documents, if in case there's a complaint regarding practitioners or particularly practitioners, we have to check the material when the complaints happen, when the incidents happen. So if it happens before the new guidelines or before the new codes, then we have to refer to the old codes. If it happens after the implementation of the new codes, then we have to refer to the new codes or guidelines accordingly. Okay, so that's why we have to put the old codes and guidelines as well in the website for reference. So basically, in terms of these guidelines for public information, I'll touch on a bit on background, introduction, the general principle, and how to disseminate the information to public, and a bit of conclusion. So background is, as background, I want to highlight how these guidelines on public and guidelines and provision on public information is related to Dental Act. It falls under Part 8 of the Dental Act under Section 83. Okay. So it's stated that council or board may issue guidelines and directive as the council or board considers necessary or expedient, and these guidelines shall be complied by all practitioners, and any practitioner who fails to comply with the guidelines or directive shall be subjected to disciplinary authority. That's why I mentioned this now in the first presentation. The topmost list of disciplinary authority covers the CPC and also guidelines. Okay. So this is the recent guideline enforced on 1st July 2022. This is the 4th edition actually, and it was endorsed by the MDC during the second MDC meeting on 14 March 2022, and also presented in the first National Dental Therapists Board and approved in their first meeting on 8 June 2022. Okay. Right. So as introduction, what is the purpose of the guideline? Is actually to explain the obligations and the responsibility of healthcare advertisers, and to describe advertising that is prohibited. That means something like the do's and don'ts, and also outline the use of factual information in advertising. So in this new guidelines, similar to the code, you have rearranged the section accordingly, and there's a lot of some new provision in these new guidelines. Okay, so basically the scope, the context and scope of this guideline touches on advertising, whereby advertising, as we know, is a useful way to communicate our services to as practitioners to offer the public, so that the public can make informed choice. But this advertising shall not have false or misleading or deceptive info, and has some thought or solicit or encourage the use of services by any practitioners. So that's basically the principle in advertising of healthcare, basic dental healthcare. So when we talk about the advertising messages, the medium will cover verbal, written, or electronic transmission. And for this target group and implication of this guideline, so the target is all practitioners under Dental Act 2018. And as mentioned in the Dental Act, any violation may subject to disciplinary authority by the MDC or MDTB as the case may be. So when we talk about public information, the guidelines have listed general principle. So basically, general principle 1 is information provided must be factually accurate and capable of being substantiated, and must be not exaggerated, false, misleading, or deceptive. Okay, that's the number one principle in this public information guideline. The second principle is the statement describing the services or facilities available must not contain laudatory terms indicating subjective praises, commendation, and compliments. For example, the best dental clinic in Malaysia, the best dental surgeon in Malaysia. It should not contain such laudatory terms. Okay. All right. And then general principle 3, the information provided shall not draw undue attention to the practitioner, be a nature that could reasonably be disregarded as likely to bring the profession into disrepute, make a claim which cannot be substantiated, and recommend a specific product using the professional qualification. So this is the don'ts in the public information as dental professionals. Okay. Number 4, we also cannot use comparison either directly or by implication between one dental facility and another. Okay, we cannot compare. General principle 5, in terms of testimony from patients, it can be published but with the patient's consent. Okay, and when it's published, there should be no monetary inducement or rewards involved in obtaining the testimonial, right? But in terms of confidentiality and personal data must be protected at all times when this testimony is being published, right? General principle 6, practitioner must have a list of clinical procedure fees available in the clinic premises. And also these fees must be displayed at the official, may be displayed at the official website of the clinics and or social media platform under the name of the practice. Okay, this is something new. And the PIC of the clinic should be the account administrator of this social media platform. Okay, so it has to be properly managed and administered by the PIC. General principle 7, any images used must be consented by the individual involved. And also something new that we added in this guideline is all photos and images must be credited in compliance with guidelines set by relevant acts and regulation. For example, the PDPA Act and Copyright Act. Okay. Right, so that covers the 7th general principle in terms of public information. Now we move on to dissemination of information to the public, right? So basically, start with name of practice. As mentioned, as we all know, name of practice should be decent, appropriate, and reflect professionalism. Right? And the practitioner shall not use a similar name of an existing clinic in the same locality. We have questions regarding this name, whereby whether you can use such name for your new practice. So basically, it comes back to this guidelines and provision for public information. The name has to be decent, appropriate, and reflect professionalism. If the name chosen cannot justify what is any of these three criteria, then it might be not acceptable name to be chosen as the name of the practice. Also in the guideline stated that it should not be a similar name in the same locality, but we do have question as well from practitioners that a similar name in different locality have induced some confusion of patient as well. So they wanted to, such practitioner wanted to have the names to be, what they call it, special, the name to be their names exclusively, but then the MDC cannot do anything unless the name is a trademark names or it has been registered as a trademark name so that another clinic cannot use the same name even at different locality. So it's beyond MDC if they want to use the same name in different locality. Under the name, the dental clinic name as well as what in the old guideline, the permissible wording shall be general practice, klinik pergigian, pusat pergigian for general practice, and for specialist practice is klinik pergigian pakar or pusat pergigian pakar. And we have emphasized in the guideline that the word pusat shall only be used for a group practice. Okay, So the solo practice cannot use the word pusat. So in this guideline also, we have listed the media for public information. At the moment, there are only 10 allowable media for public information listed in this guideline. Covers the signboard, billboard, mass mailing, pamphlets and brochures, banners, books, articles and publication, interviews and lectures, broadcasting, TV and electronic information media, the internet, and also vehicles. Okay, so as you can see, one or two media here is a new media that is listed under this guideline compared to the old guideline. So we go to the first medium, which is the signboard. These are the categories of permitted signboard: the main signboard, the subsidiary signboard, directional signboard, professional plate, consultations hour signboard, and list of services provided signboard. So in terms of main signboard, it shall comply with the regulations by relevant acts and also other local authorities. So in terms of the name, it should be the same name stated in Borang C and Borang G in the according to the 586 Act. And the language used should be Bahasa Melayu lah, Bahasa Malaysia. And additional translations in other languages, for example, English or Mandarin or Tamil, can be used but shall not be larger than the primary language. And additional contact information is permitted, including telephone number, email address, and now in the new guideline, we have included as well website, social media messaging apps, and also QR code that can be put up in the main signboard. And logos are allowed as Appendix A. This is not new. This has been in the old guideline as well. So in terms of subsidiary signboard, it can be either fixed on the exterior or in the interior of the facility, and no other words than those specified in the main signboard are permitted. So it just has to be same or less than the main signboard. And if we compare to the old guideline, there's no dimension specified in this updated guideline. Okay. In terms of directional signboard, it can be within facility or outside facility. If within facility, it only should bear the name of the facility, the floor or room number, and indicative arrow. And at the outside facility, it should bear the name only and arrow pointing to direction, and also conforms to the regulations of the relevant local authorities. And size and limit on illumination is no longer specified under this new revised guideline. Okay, as we go back to the old guideline. In terms of professional plate, these are the do's and don'ts. It can only be carried, only the name of dental practitioners with professional titles. Okay, the dental practitioner's title, whereby the division 2 cannot use the title doctor or DR or doctor, and it should only carry the basic and additional qualification deemed registrable by MDC or MDTB, the registration number, and honorary titles, okay, by state or government, central government. Okay, and a partner, associate, or assistant may have their own professional plates too. But in this professional plate, it should not carry honorary professional qualifications, additional qualifications not approved by MDC as published on the MDC website. Okay, so these are something new that we have included in the new guideline. This is in line also with the CPC, where there's no more provision on honorary professional qualification. Right. In terms of consultation hour signboard, it can be either in the form of plaque, plate, or stencil on the wall. It has been specified in this guideline. And it must be fixed in front or within the clinic premises, and should bear only the name of the facility and consultation hours. Okay. That means no other information like offering services or whatever, because it is just limited to consultation hours. And then, however, in the new guideline, there's no size of the board that has been specified as compared to the old guideline. The other one on signboard is on list of services provided. It can only has list of services approved by the relevant authority. Okay, for example, CCAPS, we have listed all the services when registered the facility. So only the signboard can only display the list of services that has been approved. Okay, the second one in terms of medium of information is on billboards. Okay, this is something new. Something new that is related to the current development in Malaysia, where we have to see advertising using billboard has been widely used now. But that's why we allow information on billboards for dental practitioners. However, it shall comply with the regulations by relevant acts and other local authorities. It is the same as the main signboard. It can only display the name of the facility as stated in Borang C and G. The primary language should be in VM. Additional language can be permitted, but not larger than the primary language. Information is permitted in the billboards, and also logos are allowed. So the conditions are the same with the condition for the main signboard. Okay, so there's no promotion, there's no other info that should be in the billboards information. So in terms of mass mailing under medium of information, this is only permitted when sent to our own patient, bona fide patients of the practice under one or more of these circumstances listed. Number one is on the commencement of the branch practice. And number two is on taking over or merging with another practice. Number three is entering or dissolving a partnership with another practitioner. Number four is on relocation of practice to new premises. And number five is on closure of practice. So basically, mass mailing is only allowed to our own patients based on these 5 circumstances only. So it's not for other promotions, reminder, something like that lah, right? Number 4 on medium of information is on pamphlets and brochures, whereby it should only contain educational information and basic information of the practice and also the service provided. Not more than that. And however, in this guideline, there has no restriction, there's no specification on the place of distribution. The old guideline mentioned about it can be only distributed in hospital, clinics, airport, something like that lah. But this guideline, they has not put that specification. Number 5 on the medium of public info is on banners, and it must conform to regulations set by local authorities and only allowed to announce the opening of new dental clinic for purpose of public info, and shall only be displayed upon receiving no objection letter from CCAPS during the clinic registration procedure. So it's not before you receive such approval letter. So the banner can only be up when you receive the no objection letter. However, in this guideline, there's no more duration limit specified. In the old guideline, it has specified that it has to be taken down 30 days after the opening. But no, this time it's not been specified. But I guess it's self-explanatory. Who wants to put banner for so long when the banner is opening soon? It's already open, right? So basically, the medium of public info number 6 is on books, articles, and publications. The names is permissible to be published, and we can add qualification numbers, registration numbers of MBC and MBTB, or also the place of practice in the publication. But this publication of names should not unduly emphasize in large, heavy print, and must not be laudatory editorial references to the author's professional status or experience. Okay. So this is what are allowed and what is not allowed, right? Number 7 covers about the public information in terms of interviews and lectures. In terms of lectures to the lay public, as practitioner who delivers lectures, they should request the chairman to be circumspect with the introductory remarks concerning the professional status and achievement. So to be just modest enough lah, right? And in terms of press interview, you can, as practitioner, can give can respond to press interview, but have to strictly adhere to this regulation as well as other codes, as well as other obligations related to the Code of Professional Conduct and so and our Act. And the responsibility of the contents of the interview basically rests solely with the practitioners. So we do not comment or have relation to what are the contents of the interview, of the information given during the interview. Okay, but it has to be strictly adhered to the Act and guidelines that is related to us. Number 8 is on broadcasting, the TV and also electronic information media. So basically, practitioners are permitted to participate in the radio, TV, or in other electronic media. However, they have to observe appropriate ethical standards, and they cannot seek to place themselves as advantageous position over other colleagues. Okay, so this the do's and don'ts. Right now, we cover about the number 9 in the medium that's allowed in this guideline, which is the internet. So basically now it's allowed to we are allowed to set up websites, social media and mobile apps to inform patients about the practice, okay, about the dental practice. In terms of website, the content may include all these items: the name of practitioner, registrable professional qualification, MDC number, practice address and maps. Home address is included in the guideline, but I'm not sure how we want to put home address in the website, but it's included in the guideline. Consultation hours, telephone and fax numbers, emails, social media addresses, web page, logo, photograph of the practitioners also allowable. List of services provided, fees, educational materials, date the last of the last update, and any other information required by acts such as Company Act 2016. So that is allowable on the website. But when you publish the treatment list of treatment in the website, it should not. It has to be mentioned that it may not be appropriate for every patient. So there's a conditional, or the patient need to be assessed accordingly before such treatment can be imposed upon them. Right. So number 2, in terms of internet, is on social media. So as practitioner, we have to be aware the obligation on or under the Dental Act, and also the regulation, and also comply to the guidelines set by Council and also Dental Therapist Board. Okay, mass emailing, as mentioned before, only permitted to our own patients under specified circumstances that mentioned before. Another mobile apps, clinical mobile apps is permissible, but must comply with the Dental Act and regulations and other regulations and guidelines set by MEC and also other legislation. And there's a new provision under the internet that have been included in this guideline, which is the push technology, whereby it shall only be used as an avenue for public info with consent from the recipient. Okay. Right. This one I want to touch a bit on social media. As mentioned before, those in we have to be abide by laws and ethics, but those in government service, okay, now basically dental officers, dental therapy, therapy. In KKM particularly, we have the social media ethics, tata etika penggunaan media sosial oleh warga KKM, and also we have this etika penggunaan media sosial oleh pegawai awam. So basically, we have to comply with this guideline as ethics on social media as well. Okay, just a friendly reminder by the integrity unit. This is some example of what have been virally published on website, whereby a practitioner go against DSAs, practitioners make general comments on another practitioner. So when we publish or when we share this information on our own Facebook, personal Facebook. Basically, we cannot control, even though it's not a public post. But it's basically we cannot control who have seen the information and who might have viral it, and then see what's the implication whereby the first posting by a practitioner has been viral to another page that has nothing to do with dentistry. So this has tarnished the image of the profession as well. When you do some general comments like this in relation to the dental profession. So just be aware, be mindful when you post something on your own personal Facebook as well. Okay, number 10 is on the vehicle. This is something new. Limited to the company registered vehicle for the facility only, and the content must comply to this guideline as mentioned repeatedly in terms of under the main signboard, billboards. Okay, so this is the basic info that can be displayed in this vehicle's information. And on top of that, it must comply with the relevant authorities such as the Road Transport Department regulations. Okay. All right. So we finished about the 10 medium of public information. Now we touch about on the announcement. So announcement is actually allowed of the primary practice, the opening of branch practice or change of the address of the practice. So it can contain photographs and logo, and can include names, address, and contact numbers of the clinic organized. In case of you organizing some oral health campaigns, these names, address, contact numbers of clinic involved, and the logos may be included for oral campaign. But of course, you have to bear in mind that it cannot. That's the limit of information that you have. You can put in your announcement. No other information allowed. Another thing on provision of public information is on dental product endorsement. As dental professional, we are allowed to sell or recommend oral health related products if it's the best way to meet our patients' need within our premises only. But we must make sure that factual information about the products is provided and must be verified evidence-based. Okay. And but in terms of dental product endorsement, we should not include patients towards specific product, and should not include activities that lead to conflict of interest in the management of patients. Okay, and we also should not express or imply the view shared by our own view shared by the whole profession. So it's our when we endorse something or recommend something, it has to be our personal view, not shared by the whole profession. In terms of health screening camps, any groups or organization might organize a free dental checkups for publics, and the names of clinics, number, address, the info, basic info may be published by the network. Okay, I'm back. Okay, girl? Just now
Okay.
okay, yeah. Just now I got disconnected. Okay. Uh, okay. Right. Thank you. So we proceed. Health training camp. I repeat again. The groups or organization might organize clinic phone numbers and that's basic. Yeah, got disconnected again. So am I back? Okay ke?
Okay, dah balik dah.
Alright, okay. Sorry, ada a few disconnection tadi. Right, so basically in terms of health clinic camps, any queries for additional information must be handled by the organizers. Okay. Now we move on to the third party involvement as stated in this guideline. As practitioner, we can enter an agreement with individuals or organization that can inform our services to the public, provided that this agreement does not permit or compel unethical conduct. Okay, so basically when we do this contract, the practitioner is required to deal fairly with public and our fellow colleagues. And also practitioners are advised to be very careful in dealing with third parties that provide the care program, and there's you should be ensure that there's no conversing, no fee splitting, and it's all open to participation by all practitioners. And it is unethical for practitioners to contract the services gitu, that make it difficult to render in timely and reasonable manner. So basically, when we choose a third party vendor, we have to be responsible of what we have chosen to do, and please have a proper contract lah. Otherwise it will be very difficult to cover you up when we are imposed with such unethical manners by the third party vendor. Basically the third party ni they probably don't have the idea of what's the legal implication, what's are the ethical what is the ethics that have to be bounded by the profession. So you have to be basically requires you to deal fairly for this third party involvement. Okay, now I think we have come to the last part of the guidelines. That is the Appendix A, whereby it gives the guideline of the use of logo. Basically, the logo has to be non-heraldic. That can be used as identification of our dental practice, and the practitioners is personally responsible for the logo that is attached in their information, and also the logo must reflect a professional profession, a good image of the profession. So basically, that's why when we have logo that doesn't reflect professional image of the profession, it is considered as not not complying to the guideline. So I've come to the conclusion of these information guidelines on public information, guidelines and provision on public information. So in essence, public should be informed of dental services available. That is what we all wanted, and we all think that the public should be aware of our dental services, That's why ethical dissemination of relevant information regarding our dental practice is necessary to be given to the patient in the most appropriate way lah. And the provision of practice information all should be conform to these revised guidelines. Okay. So that's all on the guidelines and provision on public information. So I pass back to Dr. Aziz for our next agenda. Thank you.
Okay, thank you, Dr. Nurul Shakiri. So we move to the Q&A session. So any question from the participant on the screen? Some of the question in the chat box, we have addressed it, some of the question, yeah. So any question from the participant on the screen? Please unmute yourself, yeah. And please, any question? Dr. Eliza has raised her hand, yeah. So any question?
Hi Doctor, Assalamualaikum.
Salam.
Dr. Nizam here. I would like to ask a question to Dr. Nurul. Doctor, this is regarding patient consent. My question is regarding patient consent under the age of 18. Is it valid if consent taken from the guardian, like siblings, grandfather or mother? Or is there any extra document needed for that? Thank you, Doctor.
Okay. Right. Thank you for the question, Dr. Nizam. As mentioned in the CPC, consent for those below the maturity of age, which is 18 years old, can be requested from the parents or legal guardians. Okay, so it comes. This also covers those who above 18 that has some mental disability, that they cannot, or unconscious, that they cannot give proper consent during the treatment. So the onus is given to the legal, the parents or legal guardian of the patient.
Thank you, Doctor.
Okay.
Okay. Another question?
Hello, Assalamualaikum. Hai Doktor.
Salam.
Saya Dr. Hafiz daripada Dr. Klinik Pilihan Kuantan. Saya nak tanya, di last I check, the PIMS still under maintenance. Bila DPIMS akan buka balik macam biasa? Terima kasih.
Dr. Hafiz ya, daripada Kuantan. Okay, basically DPIMS sekarang ni sebenarnya DPIMS telah pun akan ditutup dan digantikan dengan new database. Dia ada panggil Malaysian Healthcare Practitioners System, MHPS. Di mana ada 4 regulatory bodies dalam sistem yang terbaru tu, which is MDC, MDTP, Malaysian Optic Council dan juga Malaysian Allied Health Council. So basically kita tidak, DPIMS tak akan dibuka kembali lah. Kita akan ada sistem baru. Cuma sistem ni ambil masa untuk di go live. Basically initial planningnya akan go live 1 Januari tahun ni selaras dengan Akta Pergigian baru. Oleh bagaimanapun kita ada masalah dengan kewangan untuk buat online payment. So the thing has been deferred for quite some time to get the approval in terms of online payment. So kita baru je dapat approval dan dia akan buka untuk module registration dahulu dalam masa terdekat. I guess it should be maybe August lah sebab kita target Julai pun dah lambat. Maybe August akan buka untuk registration module dulu. Tapi untuk module untuk renewal APC masih belum boleh dioperasikan until the registration module dah up for quite some times. Baru APC module akan go live. Okay, so tapi itulah in terms of new system, we are expecting some glitches as well lah sebab new system kan. So kalau I take this opportunity to remind especially the private practitioners, kalau you nak renew for the next upcoming APC for 2023, you can do so by manually lah, download the form and pay the manual fees manual and send the application to the MDC, because as mentioned by Dr. Nurin tadi, our due date for APC now has been brought forward from 1st December to 1st November under the new Dental Act. So basically now we are open for the application for new APC, but since the system is not up yet, we can do so manually. Otherwise nanti kalau system dah up, we cannot ensure whether the running will be smooth. Nanti lepas 1st November nanti you kena late fee pula. Okay. I hope that answered the question.
Yes, thank you.
Okay.
Yep. Okay, crystal clear. Alright.
Okay, in the chat from
Allow
Dr.
me
Ahmad
to read some of the question in the chat box. Yeah, for question from Ahmad Hazib. Can we get clarification if consent is considered valid if the signature given by the patient is an electronic signature? Because many clinics are thinking of going paperless, but are still wondering whether consent must be hand signed on paper or is the digital is okay, is acceptable.
Okay, so far we have no issues in terms of consent either digitally or on paper. But the main what do you call it? The main thing here is you have to get it to be consented. Okay, so either electronically or manually, you have to prove that the such consent has been taken from patients.
Okay, is it clear? We move to a question from Eliza. In regards to APC, can a permanent resident be able to practice in Malaysia or own a dental clinic?
Okay, this question I'm not quite clear because in regards to APC, but then about practice in Malaysia own dental clinic. Okay, girl, because I got connection unstable. Okay, girl, can you all hear me?
Yep.
Okay, right. Okay. Basically, in terms of practicing in Malaysia, so there's two parts of the question. Basically, practicing in Malaysia, permanent residents, Red IC, you can apply for APC if you are registered with the dental council. Okay. Foreign practitioners, they can apply for temporary practice certificate to practice in Malaysia. They are not registered, but they can apply for TPC, subjected to terms conditions listed in the Dental Act. But in terms of own dental clinic, that is not under the Dental Act, is in the it's governed by Act 586, and you have to check with the CCAPS in such requirement. Okay.
All right, Eliza, is it addressed your question? Okay, we move to the question from Yasmin Kamaruddin. Hi, the guidelines state that we are not allowed to promote a specific product on social media. Does that mean we are not allowed to promote Invisalign service or on social media? Would be advisable advertise clear aligner therapy instead?
Right, thank you for the question, Dr. Yasmin. Basically, if you want to promote specific product, as mentioned, it's not allowable. So you have to promote in general. That means if you're promoting clear aligners, therapy state, with not mentioning of such specific product, then it's allowable. The same goes to like when you are promoting toothpaste containing fluoride, for example. That means you are promoting toothpaste containing fluoride in general, not specific brand or whatsoever that is related to that particular toothpaste. Okay, so it has to be in general in terms of the treatment, not the brand.
We move on to the next question from Dr. Yuan Carmon from PKPD Kintang. Regarding wording on the professional plate, what are some example of honorary professionals qualification that should not be included?
Okay, thank you, Dr. Yun Kamon. Okay, basically, if you refer to the old guideline, there has this honorary qualification allowable to be included, such as FIDC, what else? Because the old guideline is still in the website, you can always refer to that. So basically, now such honorary qualification is no more allowable to be included in the in any of the what do you call it, signage or name cards or letterheads, etc. Okay, so basically the reason, if I may share, because we also don't we have no idea who's the awarding bodies, what are the criteria for awarding such honorary qualifications. So it's not clear. That's why it has been taken out from this current guideline.
So back to actually the sort of same issue highlighted by Hugh Zing Lim, but his question is, can we display our certificate in the clinic and can we display on our business card?
Certificate. Oh, that means honorary professional certificate. Display on our business card. If you want to, there's no permission that not allowing for you to display any other certificate in the premise. But then how I can't imagine how we would display the certificate on business card. Maybe ada image or something like that. It would be too small. But the thing is, shouldn't be in your names too, shouldn't be any other qualifications, honorary qualifications to be included in all the specified signages and also name cards and professional plates.
Is it addressed your doubt? Okay. We move to another question from Yasmin Kamaruddin. Also, could you please clarify what is meant by clinicians should not draw undue attention? Would this affect dentists who are social media influence? Thanks.
Right. Okay. As mentioned, this one will actually depends on how would you interpret it. Okay, some from my point of view, some dental practitioners maybe as promoting who are social media influencers, maybe are just doing their obligations to patients as what is the code in terms of oral promotions and etc. But if you notice that such influencers, social media influencers has gone above the line where they're trying to promote or giving undue attention to themselves, then you may raise this to the council. Okay, so it depends on how you you look at the situation, and if there's enough evidence, supporting evidence that such influencers is actually drawing undue attention by promoting themselves on social media, then by all means you can complain, direct your complaints in return to the council. So investigation will be carried out, and the accused practitioner will have to explain themselves, and the PIC, the Preliminary Investigation Committee, will determine whether there's a case to be answered to the council.
Thank you, Doctor. Also, another question from Dr. Chan. Can put FAMM or AMM on the nameplate? Thank you.
Okay, if you refer to the old guidelines, if AMM is all listed under the honorary qualification, because if you refer to the current guidelines, is only can include your qualification that listed in the MBC or MDTP, and also honorary titles given by states. So basically, FAMM, AMM, FIDC is not listed on MBC as a recognized qualification by MBC, so it clearly is did not comply to the current guideline.
Okay, thank you. Also, actually, I saw some participant raise their hand. So, any question from the screen? If not, I'll proceed to the question in the chat box, yeah? Question from our unit actually. As legal guardian has to be appointed by the court in case where parents are not present, can a patient who is a minor, direct relative, for example, grandparents or siblings, sign the consent?
This is quite interesting question. Okay, basically, we have to look into the matter wisely. Okay, if possible, we have to get the parents' consent. But if in the cases that you think that is emergency or etc., then you can actually do whatever that you can do at that particular visit, so that you can manage the patient accordingly. Otherwise, it will be best to have the parents to get consent unless they can prove that the legal guardian is appointed by the court. So basically, it all goes back to the our professional punya judgment lah. Okay, but to cover up yourself, no consent is worse than having a consent that is not valid lah, basically. So that is what I'm trying to convey, that you have to, at least you have some consent to cover you up, and then make sure that on the other hands, make sure if the consent is there, it has to be valid lah. Otherwise, things might go wrong if the consent is not valid consent. Sometimes we also do things based on our own empathy or whatever, but sometimes it turns around to be the other way around, that it bites back to your own or yourself. So everything you have to be covered lah. Right?
So other question from the screen? Any question? Oh. Question from Ahmad Hazim. I'm sorry, but I believe NDFC could do us the courtesy of explaining what undue attention to practitioner mean. This is because when we don't know what the actual guidelines are, it is hard to report and look for evidence, especially for social media influencer?
Actual guidelines is what is listed in the guide. So, as I mentioned, if the if the social media influencers claim that is the information or whatever they share is their obligations to patient as what is in the CPC. So basically, they are covered. But then, if you think that such influencers are doing things that are beyond what is in the guideline, then it is subjected to further deliberation by the council, as mentioned in the Code of Professional Conduct as well, because it doesn't spell out, some things are not clearly spelled out. So basically, it will come in certain cases will become will have to look into case to case by the council. If you find there is enough supporting evidence to support that such influences has gone beyond what is allowable in the guideline.
All right. So okay, Azim, did it address your concern? Yeah. Okay. So any question from the floor?
Doctor, just have one question about the CPC. Is it applied for both for all the practitioners, including therapists?
Sorry, come again? CPC, come again? Can you repeat the question, Dr. Nurin?
For CPC, for the current CPC, is it applied for all practitioners? Is it for only for dental surgeon, or is it for all our practitioners, including dental therapists?
Yes, the Code of Professional Conduct, CPC, covered all practitioners, which mean the dental surgeons and dental therapists.
Okay. Any question? Okay, if not, we will end this webinar. So, thank you so much, Dr. Nurul Shakiri, for your time and for your willingness to sharing your knowledge with us. So, on behalf of Bahagian, oh, okay, sorry, we have another question. Sorry. Okay. We have another question from Klinik Pergigian Bandar Maharani. Do we have to take consent in case of management of emergency procedure, or does verbal or implied consent is enough in this case?
I think basically consent has to be taken by even in emergency procedures by whoever is available at the event, or if you're talking about patients who can actually who is actually sound mind and everything, then it can be considered legal whereby verbal or implied consent is taken. But then you have to make sure that the patient is in the sound mind before they give that such verbal or implied consent in terms of emergency procedures. That is a bit tricky lah. Okay.
Is it addressed your doubt? Okay, any question? Any more question? We can take another 3 question perhaps. Yeah. Any question from the screen? Any question? All right then. So I think we end our session. So on behalf of Bahagian Kesihatan Pergigian Negeri Johor, we would like to express our warmest gratitude to Dr. Nurul Shakiri for her time and her willingness to share the knowledge. Ada lagi? Sorry, ada lagi. Okay, we have another 2 questions. Yeah, 3 questions. Okay. If a practitioner having an active APC but practicing address is not listed in the current APC. Okay, is it considered valid or not if a practitioner having active APC but they conduct their practice but the practicing address is not listed in the current APC?
Okay, let me take the question again, Dr. Zio. If a practitioner having an active APC but practicing address is not listed in the current APC, okay, that means okay, according to the Act, under APC for APC, right? Yeah. Okay, 37 sub B, the practice certificate shall specify the principal practicing address and all other places of practice of the practitioners. So basically, if it's found that a person is having doing practice who practice in a premise that is not listed in his APC, he can be found guilty because not having listed the practice, the practicing address at these active APCs. Does it answer your question, Dr. Zio?
Can I add a little bit more?
Can, sure.
Okay. For practicing address, of course you have to listed all your practicing address, especially for clinics that have a same need. I mean, a group practice. They have a few branches. If they want to practice to any of the addresses, they must list it as part of their practicing address. Right now, there is no limitation for how many clinic you can practice. Therefore, and the fees is limited to 300 ringgit, right, Dr. Nurul? So I think there's no problem. You need to have the APC for that particular practicing address.
Can I further elaborate on this question?
Sure.
Okay, this always happen during the locum. So when they go to apply for locum or they go to work as a locum, so usually they work in the very short notice. So their APC, they have an active APC, but the APC is without the address of the clinic they locum. So question number 1, is it considered a valid APC or not? Question number 2, if the place they practice, they have another colleague which have a valid APC there, will it consider that it's actually working together with a person with illegal APC? Will they be penalized?
Okay. Thank you, Dr. Zio. Okay, number 1, if you consider for question number 1, whether it's a valid APC, a person who have APC can be considered have a valid one if it's listed all the places of practice. So that means if he practice at the places which is not listed in the APC, it is considered invalid in that particular practice. So basically, things will go wrong when such practitioner is practicing without an APC at that premise, and then an enforcement officer is going there for inspection and etc., and found someone who has no APC treating patients there, they can make report to the MDC, and such what do you call it, disciplinary action also can be taken to the MDC, as well as breaching the Dental Act 2018. For the knowingly practicing with a person without APC, the word knowingly is quite subjective. How you want to prove that person know and don't know is a matter of debate lah. Okay, a person has to prove themselves if they want to escape lah. If they don't know that they are practicing with someone yang without APC, then they have to be really justify why they do not know the other person have no APC. Then otherwise, if knowingly practicing with someone without APC, then they can be charged.
Thank you. I think MDC can issue a official statement regarding this status to make clear to everyone regarding the valid of the APC if without the practicing certificate, the practicing address. So because there's actually quite a number that assume that I have an active APC, this means I have a valid APC.
So okay. They got the impression that they have an APC, but not stating that premise lah. Okay.
Thank you.
Right.
I think we are slightly okay. We are different from our medical practitioner lah, because when they have valid APC, they can practice anywhere. So for our regulation, our dental has specified that we need to practice only at the specific address only. So let's say I have a few already practitioner. They say that they practice with the same group, and then they need to cover for the other practitioner in those group in those clinic that the practitioner is MC or something like that lah. Then it's actually an offense when you practice when you don't have the APC for that particular address. So I think I thought that everyone has understood this, but it is good to know that this is not well understood by all the practitioners.
Right, we move to I think this is the last question from KP Kuala Kemaman. Is it true that only parents are able to give consent for treatment? If pelajar sekolah asrama, can their teacher give the consent?
Okay, I think there has been a wrong practice lah. All this the echo. Okay, all this while regarding school when we are treating our school children dekat sekolah, right? Sekolah asrama. So basically, only parents can give consent for treatment for their children. So basically, kalau teachers yang bagi consent is considered not valid lah. Okay. So I think in terms of consent ni, we have gradually improved our ways of getting consent. I know that kita dah panggil, we have developed a comprehensive consent form in government setting lah. I'm talking about government setting. We have developed a proper consent form, proper guideline for consent, etc. So we have improvised our consent taking for our patients. But I wish that it can be taken seriously by the private practitioners as well lah. Okay, but so far, hardly we encounter any disciplinary complaints regarding consent. Basically, it's more about what we call this competency is the most complained regarding our dental practitioners. And when we look into their records, we found that their records, even charting is not complete, and sometimes there are no consent. So that's why the implication goes way beyond what is the initial complaint by the patient.
Okay. Last question from Siti Fatimah Muhammad. What if we get verbal consent from parents via phone call? I mean for emergency case.
Okay. Okay, via phone call. Even in case of emergency, usually kan in your what do you call this sekolah especially lah, they have this consent, blanket consent by parents. That means parents give consent to the school ataupun to the to the team ke yang akan bawa the children to in case of emergency. So basically the consent is still basically from the parents, but it's a blanket consent lah. In case of emergency, I bagi consent to bring my child ke apa benda. That means it's still consented by parents. It's not because we are already covered by the initial consent, blanket consent, saying that in case of emergency, we will treat your children accordingly, macam itulah. Okay. Okay. Eliza. We have this question. Dr. Azia ada lagi ke ni? Sudah terputus.
Okay. Regarding main signboard, can please elaborate regarding size, font type, etc. Is there we need much larger and flashy signboard? Is that allowed?
In this new guidelines, we have not specified the size, font types, etc. Illumination, semua tu is no longer specified in this guideline. However, it's stated there it must be complied to the relevant authorities. That means such as the local authorities and also DBP in terms of language use, etc. Okay, so and in terms of font, in the guideline, it's only specified that the font should not be larger. The font for other language users should not be larger than the font used for the main language, which is Bahasa Melayu. Okay, that's the only specification that's stated in the guideline.
Can I add something regarding this?
Okay, sure, Dr. Sio.
Because I'm one on the committee of draft the guideline for this
Yeah.
signboard. Okay,
Great.
the reason why we didn't specify the dimension, everything, because the signboard is actually under the jurisdiction of the municipal. So every municipal, they have different requirement. So
Right.
once we specify it, that it go against the local municipal, then you're going to have a trouble. Because the signboard is under the authority of the local municipal. So you need to actually find out from the local municipal what is their requirement for the signboard. Just like, for example, JB, because the local municipal, by the order of the Sultan, we cannot have more than 4 times 20. So if I specify you can do 4 times 22, then we're having a problem.
Great. Thank you for sharing, Dr. Sio.
So, any question? All right. So, any question? Any more question? Alright, so dah 3 kali nak end tak jadi nak end. Okay. So I guess no question from the screen, yeah? Okay. So we will end our webinar today. Our